I guess from where we were last time, we probably are ready to take up, I think, with automobile members, something that they may have gotten worked up for us.
Over the time off, and it's really sets up a way that an auctioneer can auction off motor vehicles at a going out of business. Use that term rather than liquidation because that's the term that's been used in the UCC. Maybe 10 or 12 years ago, we had a lot of problems with people having multiple going out of business sales. And so legislation was passed to accomplish that. I have a few copies of things I've drafted. Not to say they're basically what this says is that you don't have to have a license at a motor vehicle dealer if you're selling cars at a bona fide going out of business sale, in compliance with the Consumer Protection Acts. It requires that the vehicles be owned at least a year prior to the sale. That's to keep people from loading up on vehicles at the last minute. Entitled in the name of the business, and if there's going to be a sale, that I think this is from you, and that they have to give 14 days notice and list of what they're selling. And it is incidental. Incidental to the sale. So that's where we are. I thought it was an easy, simple way to do that.
The way it's put together is it goes into 5517-120, which is exceptions for certain transactions. It's where the other exceptions to the general dealer law is, and I think, as Risa pointed out in her draft, I think earlier, I think that's where you want to put it. You don't want to put it as an exemption, as an exception to the public auto auction law. It's what transactions don't require a license at all, and I think that's consistent, and it would certainly be consistent in the statute that dealers use, and it would be clear to the Motor Vehicle Commission that in these instances, and there are three provisions that are specified in the 4718-104, which is the Deceptive Acts and Practices provision of the Tennessee Consumer Protection Act, where these type sales are discussed, and that's what that language "in compliance with," and that's the reason those are specified, because they clearly address these type sales.
Speaker, I have a question.
Yes.
At least 1 year prior, the auctioneer gives 14-day prior notice written notification to the Tennessee Motor Vehicle. Is that all that would be necessary, or will we need to have a response back from you all that you got it, or you just need to postmark it and make sure it's there 14 days prior, or at least up to 14 days prior, and there's not going to be anything coming back the direction of the auctioneer?
Or anything, just notice to them that your intention is you're going to handle this sale. Here's the number of vehicles that are involved, and I would think they'd probably want VIN numbers, but we didn't go that specific. That was the intent is you're going to give a list of the vehicles that they do comply with, been owned for a year, and is a bona fide going out of business sale, which the Consumer Protection Act speaks to.
I think you could email it.
Yeah. Okay.
A perfect question. I also had written down what was that you contemplated would be required of the commission. So you mentioned the VIN number, that there'd be some tracking. What administratively would you want the commission to do?
Well, I think I haven't discussed that with the commission, so the commission may have some thoughts on that. But I would imagine that the commission just needs a record that these vehicles are being sold as an exception to the dealer licensing law. If the commission chose to, I guess they could go observe the sale and make sure those were the vehicles being sold. But certainly, I think in the spirit of what this task force is trying to look towards, is simply here's an exception. Here are the vehicles that plan to be sold. And therefore the auctioneer be within his rights, according to the Auctioneer Commission, to sell it in their commercially reasonable fashion.
Any other comments, questions?
I have one more thing I want to give to the commission. I just changed the wording a little bit. That the holder of a public auto auction license
John, for the sake of the recording, could you go over that again when you're back at a microphone? Thank you.
additional part that we were charged to look at was about the public auto auction license and what the requirements are to have one. And the requirements were that you have to be an auctioneer, but it's been changed to, because the anticipated new law, to have a valid auction business license with an identified responsible person. So that's what we're changing the law, this law to. You must meet the appropriate license requirements of the automobile dealers law and use only licensed bid callers to sell from the block. That's what that does. So those are the two changes, or two parts that we need to put into the law, this proposal.
Chairman, based on what we had proposed was with this ABC license category, there was every step included everything below it as well as what was new. Like, so if you were a C, you had one step. B would include C and B, and then A would include A, B, and C for all of the things that you would have to have in order to achieve those levels in terms of education, licensure, and that. So I think that's covered already in what we had proposed.
Right.
John, on your initial language about the bona fide going out of business sale, when you were talking about it, you mentioned that the vehicles would be owned for a year and be sold incidental to the sale of the business. I didn't see the incidental to the sale of the business in here. Do you think the 1 year requirement is enough, or? Oh, I'm sorry. Yeah, it's at the very
Front.
at the first sentence. Sorry.
Yeah.
Sorry.
Okay.
Just missed it.
Okay. Are you good? Okay. Bressa?
Okay, my only question on this one, on the public auto auction, is I know that in my draft and in Commissioner Morris's draft, that there was additional education for the public auto auction license specific to titles and motor vehicle law. So,
We're in concurrence with that.
right, okay, yeah, so,
Yeah.
all right.
But I think that's going to be in
In
your
the draft.
part of the code.
Right, exactly. Okay, so I just wanted to make sure that
Yeah.
someone with an auction business license didn't automatically be eligible for a public auto auction license.
Be clear for the record, are you suggesting in the part in 5517 where public automobile auctions are enumerated, your suggestion is to include this part in that section of 5517?
I just regurgitated what you had written down, but I suspect we need to say that to qualify for a public auto auction, you got to take the additional would it?
Right. Well, the holder of the public auto auction license, the public auto auction license would then be issued by the auction commission, I think is what Bob is saying. And in addition to that, they would also have to have that business license, is what you're specifying or clarifying. Is that right, John?
It's my intent.
Yeah. Okay. I just wanted to make sure we're clear on that.
All right.
So whoever holds the license for the public automobile auction license can hire any licensed bid caller. As it is right now, the only people who can call bids have had to take the course, and that is a problem, hiring help.
I think it was our intent that whoever held that license would be responsible for any and all actions that take place during that auction, even if they do hire a bid caller. I mean, that's what we're looking for, is who is going to be the responsible party that we can look to, either in the Class B or the Class A license category.
This is better than the way it is currently.
Yes.
So we're clear on that, that if Kenny got sick and needed to hire me to come up and do the bid calling, as long as he's the responsible party, that's allowed. Okay. Any other questions? John, you moving to adopt this, or
Sir, move we adopt.
I second.
any other discussion on the motion? All in favor say aye.
Aye.
All opposed? Okay. Thank you. And I think now that moves us to the other part that was unfinished, if I'm correct, is the online.
It says affiliate,
Okay.
but I don't know what.
Discuss affiliate auctioneer program. I think David had some thoughts about that. At least two or three things that we probably need to clarify, especially I think maybe how are we going to handle the ones that are currently in the program? Are they going to have to serve the 2 years? Are they going to be okay with serving their time? And how do we mesh that together if indeed this happens? Of course, I guess it's...
It may be 2 years before this happens.
Exactly. So it may be a moot point anyway.
And I can't get this to open. What am I not doing right?
Gotta hold your mouth right, David.
Actually thrown one of these during these meetings? Right. You don't have to worry with my aim and arm.
Well, the new ones have a bigger battery, so you can throw it farther.
Right. Have a better arc. All right. Good. All right. I feel much better now. All right. I put down some thoughts, and remembering that our goal here for the task force is to sort of paint some broad strokes about what we want to recommend to the legislature, and they're going to get a lot of information from us about how we would make things more efficient moving forward and more open and inclusive. But one of the things that concerned me was with the apprenticeship program. I felt like there were there's some issues that we needed to solve for the legislature beforehand to say this is what we're thinking about doing. And one of them was, what do we do with whatever apprenticeship program is in place whenever this hopefully gets enacted? what's going to happen to those people, and how do we deal with them, because they're going to be operating up until the new laws are passed, assuming they get passed, written and passed. They're going to be operating under the old set of laws, which is a 2-year apprenticeship program. That's the first thing. I know everybody wants to throw out the point system, but
I'm not for that.
except for Jeff and myself, everybody wants to throw out the point system. And I don't mind revising it or replacing it with something else, but what the point system represented was accountability. It allowed a third party to take a look at an apprentice's record during their time of apprenticeship and see what they'd actually participated in, and hopefully make an assumption that they had been exposed to the various things we want them to be exposed to. And so I think we need to kind of once again just make sure that we have some type of an understanding about what's expected during an apprenticeship program, especially since the apprenticeship program currently, as it exists, the point system really doesn't address 2018. It doesn't address online auctions in any way, shape, or form. It puts a lot more emphasis on bid calling, which we're actually going to be removing from a B-class license from the standpoint of it's not that important if you're not going to go into that. So that's another consideration. I just wanted us to be aware we need to have some type of a recommendation for the legislature for those laws that are going to get written. The third thing, or one of the things was, at what point can an auctioneer take on an affiliate? And what made me think about this was, if we reduce this down to 6 months, then a practicing auctioneer takes in an apprentice, and 6 months and 1 day later, that apprentice is now an auctioneer. Can that person now take on as many apprentices as they want? Because we're obviously not going to restrict the number. So conceivably, you could have a firm where you had an auctioneer with experience of 6 months and 1 day literally saying anybody and everybody who wants to come apprentice under me can come do that. And I'm just wondering if that's not just a bad practice. And so do we want to try to put some type of safeguard in there which allows that to evolve in a way where more experienced people are being able to put in their apprentices? I had a discussion with Addison Russell, and she actually said that wasn't necessary. And she pointed out if a lawyer passes the bar, then a lawyer could go out and hire as many different lawyers as they want, regardless of that lawyer's experience. Conversely, I pointed to the Real Estate Commission, which says you can't have affiliate brokers unless you've become a broker, and that process takes a certain amount of time to do it. So since we're reducing the amount of time it takes to become an auctioneer, are we also diluting the experience and the knowledge that an auctioneer must have in order to have an apprentice? And those were just some things that I thought merited our discussion and perhaps got some answers to.
I think practicality will actually bear out on that, in that I can't imagine somebody wanting to learn how to become an auctioneer training under a guy that just got his license saying, teach me everything you know, in 10 minutes. And I just think that most apprentice auctioneers are looking for experienced companies to go to work for. I understand technically or from a technicality standpoint that that's possible. I think in the practical part of life that most people that come want to come and learn, not to just participate in becoming an auctioneer.
Jeff, let me give you a scenario where that may not play out. I'm a deep-pocketed apprentice auctioneer who just became an auctioneer. I am paying every affiliate auctioneer I can at least $500 for bringing me an auction. And that's what I'm offering to any outcoming student who's graduated. Come work for me. Every time you bring me a sale, I'm guaranteeing X amount of dollars. Whereas right now, the way the apprentice program is set up, it's sort of murky about what the apprentice receives in the way of compensation. Some auctioneers will pay them an hourly wage when they work. Some of them will say, if you bring me a sale, we'll split it minus expenses. But imagine a scenario where a company or an auctioneer has the backing of a company that says, get every walking, breathing person you can who's an auctioneer. I want those people to come work for us. I want to own the market, and here's how we're going to own the market. So just as I said, that's why I thought it would be a good discussion to say, I would agree. I would think. Hopefully, you were right. I'm trying to think about the ways in which it would not work. So,
in addressing the switchover, I would think that the day the law became law, then if you were an apprentice, that new law would apply to you then. That's the way I would read that law. In other words, if you've been an apprentice for a year and 11 months, you meet the 6-month requirement. If you've been there 7 months, you meet the 6-month requirement. I mean, that's the way I would look at it.
But if you've been there 2 months, you still have 4 more to go.
Still got 4 more to go, right?
Gotcha.
I mean, I
Okay.
just think the law would become effective when it became effective.
Grandfather them at that time.
And yeah, that's exactly.
Okay.
Gressa?
Well, back to David's point and Jeff's point about that length of time, and I can see it in a lot of different viewpoints, and just looking at some of the graduates who have come through our program that I'm aware of, I think, while I would like to agree with you, I think sometimes that is just not the case. And I know that we have a lot of apprentice auctioneers who are in it to learn from their sponsoring auctioneers, but there's a certain number of them that are just in it to put in their time, and if they can find a way to do that without actually having any practical experience, they're out there. And so, I know right now the time period is 2 years. You have to be an auctioneer for 2 years. I can, if we shorten that affiliate program to 6 months, I can see putting some kind of a time period, maybe 1 year, or 2. I'm not attached to any of it, but I do agree that there might be a need for a time period,
You're saying there may be a need for a time period from when a person becomes an auction after 6 months and day one, they can't necessarily go out and get another apprentice. I'm not sure clear on your
right.
time
Yeah,
frame.
I think that there might be some value or benefit to that, to not only to the consumer, but also to the affiliate auctioneers and also to the principal auctioneers, is that they actually have something that they can offer, number one. Number two, it puts an extra level of some time in there of accountability to consumer. I can see the validity for that.
Those were just thoughts I had, so I'm open to hearing how we're going to resolve that, because I think we need to. The task force needs to have addressed those issues in some form or fashion as we move forward and present information to the legislature. This is what we anticipate might happen. This is how we see it being resolved.
The point system, were we under the impression that the commission would address that, if possible? If a point system is
Well, I would rather see the point system stay in place. I mean, again, there's some apprentices that go to work for very active auction companies, and some apprentices go to work for very inactive auction businesses, and they don't get the experience, they don't get the hands-on. Like I said, if you can do it in 6 months and get all of your points in, then I'm fine with that. But I'd rather have the experience requirements be in there rather than just, you're an apprentice for 6 months, now you're an auctioneer. That doesn't work for me. I think we got to have some sort of experience trail that proves that you've done some things in the auction industry before you become a full-fledged auctioneer. And then, David, if you want to add to that you've got to become, you've got to be an auctioneer for at least 2 years before you can have an affiliate or an apprentice auctioneer under you, then I'm fine with that too. I mean, I don't have any problem with that.
I don't really
know that anybody has a magical number, but something to quantify.
Well, I mean, under the law, that's what it is now. I mean,
Right.
you are an apprentice for 2 years, and as soon as you become an auctioneer, you can have an apprentice under you now. Mm-hmm. So if you want to make that, you got to be at least an auctioneer for 2 years or a year or whatever. I'm fine with that either way.
And as far as the point system goes, I just meant the point system is another phrase for accountability. And I'm for actually looking at the point system and seeing what we're trying to quantify. I think we could reduce some. Obviously, if you have a B class track, you may not need 60 points to represent each auction you do for bid calling, because all you're doing is online auctions. And so we would need to revisit the point system in such a way that it would reflect how we're now changing the licensure. Because I think every auctioneer should be exposed, whether they're going to engage in it or not, some bit of bid calling. Doesn't have to be overwhelming. But I also think, conversely, all auction companies need to be exposed to online auctions. And have some type of a training situation in that, or at least some exposure to that. So maybe looking at the point system in such a way that we keep it at, 1,000 points you got to get, so we don't make the bid calling 60 points. We now put an emphasis on other things that reflect 2018, and do that. And I'm not sure what those things are, but I know one of them would be online.
Ressa?
Well, in looking at what we actually approved at the last meeting, under the education for the business track and the apprenticeship, and changing that to the term affiliate auctioneer, it does say that it is experience-based with participation in a certain number of auctions and auction-related activities as determined by the Tennessee Auctioneer Commission for a period of not less than 6 months. And so that does, whether it's a point system, whether it's turning in sale bills or documentation, copies of contracts or documentation, that I think the commission can determine how to set those parameters, as long as it's experience-based, and that it may take people longer or may take them, less, but not less than 6 months.
Right.
I think the details of that come under the rulemaking part of the TAC, and so that wouldn't have to be within in this particular bill.
We think that the length of time that an auctioneer could serve before he sponsored an apprentice needs to be brought up here.
I definitely think that needs to be part of the statute. Let that be by statute it has to be that long.
What's some thought on that?
Well, one of the goals of the task force was to make it more appealing to those trying to enter the auction profession. So I would say we should probably reduce it. A year is probably acceptable, because that would have meant you would have apprenticed for 6 months, and then you would have been an auctioneer for an additional year, so 18 months. I think that's as around a number as any.
I agree, and it's not onerous. I don't think I don't think that's a big hindrance to getting into the business if you just say a year. So I would go along with that.
I can agree with that. That's fine. Yeah.
Kenny? Yeah. Have that in the form of a motion?
I make a motion that we recommend an individual auctioneer must be an auctioneer, licensed auctioneer for at least 1 year in order to accept apprenticeships from rising auctioneers.
Second? Motion's made and second. Any other discussion?
Yeah, actually, I am not certain from the kind of technicality standpoint of our tracking of that, how it would work. I do think that it would be slightly easier, and this is kind of operating on a presumption, for us to set it at 1 year past their initial licensure from when they became an affiliate, which would be 6 months after they became a full auctioneer. So that would be 6 months less than what you just talked about. And again, this might not be much of an issue with our internal licensing system, but it would, I believe, make it easier. So I was wondering, David, your thoughts on if it was rather than 18 months, if we were talking about 12 months total. Are you married
but don't
to
you
the
become,
18?
If I'm remembering correctly, you apprentice for you have an apprentice license. You apprentice for 6 months, and then you have to take another test, and then you are a licensed auctioneer. Yeah, see, it's a different.
So then it's just 1 year from the new license type.
Correct.
Okay.
Right.
So that
It's a separate license.
that would resolve that issue then.
That clears it up.
Yeah, it sure does. Thank you.
Any other discussion? All in favor say aye.
Aye.
All opposed? All right. One opposed? And so the point system, I think we've decided that that's going to go to the commission anyway for their recommendation. Was there anything else on that, David? Or,
No,
or anybody else for that matter that had anything about the affiliate program?
I think we've beaten that horse to death. So,
Next on the agenda is discussing Jeff Morris's red line document, which
Well, we'd gotten down to, and we'd gotten down to the public automobile auction track, which we just cleared up the exemptions underneath with our two colleagues from the automobile auctioneer. So we're now down to online auctions. And that number one is to define time listings for the purpose of this exemption in 6219-1039 as time listings means offering good for sale with a fixed ending time and date which does not extend based on bidding activity. So that was that's sort of what got us here to start with this task force, and that's the issue on the table now.
all right. Who's going to be first?
well, Mr. Chairman, I mean, I'll speak to the issue because it's been sort of a passion of mine for the past going on 24 months. I think it's important that people who want to engage in the auction profession understand the terminology that is used in their business, and anything that helps clarify what something is, what a business model practice is something that I can support. If we define time listings for the sale of offering good for sale with a fixed ending time and date, which does not extend based on bidding activity, then that to me allows business models who operate such as an eBay and that kind of thing to exist and exist in the state of Tennessee without having to go through the licensure process that we're suggesting. And it means that anybody else who has another business model is going to have to comply with the requirements and education and oversight that we're suggesting with this task force. If you're engaged in online activity where the item being sold is being offered to the public, you're receiving a commission for the sale of that item from a third party, meaning it's not yours to sell. They've asked you to go into they've asked you to sell it, and they're going to pay you, or you're going to take a certain percentage of that sale. And that auction process mimics what happens in a live auction. Then I think it's online activity that needs to be compliant with what we're suggesting.
I have a question regarding the timed listings. What brought about the timed listings into this conversation? Wouldn't the normal auction be, accepting bids based on bidding activity, regardless of whether it's online or live?
Okay. If we revisit the mid to early 2000s, online business platforms were being implemented, where, and once again I want to stress, this is only for businesses where you as an interested party to sell something bring something to me because I'm saying that I'm an auctioneer, and I can sell those items for you, and I'll receive a compensation for that. Companies were developing brick and mortar companies at the time, where what they would do is they would simply do the work for you of putting it on something like eBay, which had fixed time endings. eBay, of course, did not feel like it needed to have regulation oversight because they did not feel like it was an auction. And it actually is interesting that we've gone back and listened to the actual audio of the discussion in the legislature, and that is their very argument, that they are not like an auction because they are a fixed time auction platform. And by fixed time, I mean the auction ends at 5 o'clock Wednesday afternoon Central Standard Time, and regardless of the bidding activity, that is when it ends. And the argument that was put forth by eBay was, that is why we do not need online regulation. Okay. Fast forward to 2018 and the development and the use, exponential use, of online bidding platforms, where if a bid comes in at the latter part of the end of the sale, it then extends the time. The software allowed an individual to bid on an item, and then instead of it ending at 5 o'clock, it kicked it up and gave it an extra 4 or 5 minutes so somebody else could come in and bid. And so what you have is an ascending bid platform, exactly like an auctioneer standing in front of a crowd and saying, I've got $100, who will give me $125. I've got $125 now, $150. And the definition of an auction statutorily is bids that are raised exponentially until the highest best bid is attained. That comparison was only different in the fact that one was being conducted live and one was being conducted online. The difference between a timed fixed listing was it ended at a certain time. Anything else would be considered sort of an auction platform or an auction business model. And so those are the two differences. Fixed time means it just ends and stops, and online, the online soft close is what we call it, meaning it's not a hard close. It can continue on until such time that no more bidding occurs. That mimics the auction process in a live setting, and it's ironic that the 2006 eBay bill pointed out that very discrepancy between what happens in in a live auction with what happens in their process with fixed time as the reason why their fixed time should not be regulated. So what we're trying to do as a task force is to understand and explain to a public that may be confused that there are differences between what happens in an eBay setting than what happens in an online auction, which is the prevalent way in which people are now bidding. And currently, there's no online oversight for that. So this definition, hopefully, will clear up any ambiguity about what a fixed time listing is versus what a soft close online auction gives you, because those two are distinctly different. And right now, it is being covered under that 2006 exemption. The soft close is, and we're trying to say it should not be because it is not a fixed time auction. And I'm sure I made that as clear as mud to you. But if anybody takes another stab at it, I'm all for it.
Well, my question would be, and perhaps I don't understand all of the differences, but to me, a fixed time auction sounds like the same thing as a not fixed time auction in that, if you're on eBay, the bids are escalating and going up as someone's bidding more and more, like you would in an auction that might extend its time. The only difference is there's a hard stop on that eBay auction. So my question would be, why would simply because there's a hard stop time on the auction that not be subject to regulation at all, whereas if it extends time a little bit, then it should be regulated? I don't see what...
Let me help you with that. I don't think we're going to... We would love to go as far as you would like. As your suggestion.
Well, no, I'm just saying if you're going to treat two things differently.
I think we're trying to be politically responsible here and know that there's only so far that we can get with this. And we're willing as auctioneers to settle for this definition so that the TAC will have oversight over online auctions that extend. We'll never get the legislature to agree to allow us to oversee all auctions, whether fixed or not fixed. So that's...
Well, I see that. I guess what I'm saying is, should there be another reason other than simply it would be too difficult politically to regulate these fixed time auctions? Like, that's what I'm asking. Is there a reason beyond that you're saying?
Well, and also there's a statutory definition of auction where you're going until the most favorable bid is obtained. Okay, so when you have a fixed time, you're not going until the most favorable bid is obtained. That's the difference. In an online auction or a live auction, the auctioneer or the platform is going to continue that auction until the most favorable bid is obtained. Under the eBay law, they are not. That's the difference.
And somebody pointed out to me too, if you look at eBay now, the percentage of what they consider buy it now, they've turned into a retail store. Instead of an auction. I think it started out that way, but now it's basically turned into a retail store because everything's at buy it now or the minimum price is established from the get-go.
Mr. Chairman, and Clark, just if you want to try to fix the fixed time, that's next year's tax force. Okay.
Well, I'm not saying I do. What I was getting at is there needs to be a principled reason for treating those two things differently if you're going to regulate one and not the other, beyond that it's simply politically more expedient to regulate.
Many of us believe the principled reason is that in an online soft close setting, you are mimicking the exact behavior of an auctioneer.
Mr. Chairman.
Yes, sir.
There is no principled means of establishing the way an auction ends to justify regulation on one side and not regulation on the other side. It is arbitrary, inequitable, and unreasonable. It also possibly would be vulnerable to litigation because of its arbitrariness. It's only being done to avoid stirring up a fight that might not be winnable politically, and we've covered that. But as far as deciding whether the public is harmed or protected based on the way that the auction ends, that doesn't pass the smell test. What's really at stake in this discussion is whether auctions need to be regulated in the state or whether they don't need to be regulated in the state, because the business is headed that direction. A larger percentage of auctions are conducted online every year, and that's been the case since the 2006 exemption was put in place. And that's, I think, why we've had such a difficult time, discussing this issue, not just in the task force, but also over the last, it's been probably 4 years now. But it has to do with whether auctions need to be regulated. And just defining a timed listing, the reason it's necessary to define what a timed listing is because that's the language that was used in the exemption passed in 2006. Not a fixed time listing, but a timed listing. And when the Joint Government Operations Committee reviewed this, they determined that a timed listing included an extended time listing. It didn't matter that it was extended, it was still timed, and that was their understanding of the exemption, and so it's still exempt and has been since 2006. And so what we're talking about here is bringing an entire part of an industry that has had a lot of entrepreneurial activity in it and lots of business models that have been established, fleshed out, and developed. We're talking about that, subjecting that to a regulatory regime that was designed and implemented to regulate outcry auctions. And I think the reason we're talking about that is an effort to restrict competition. An argument like this just doesn't pass muster because it's completely arbitrary as to how you end your sales. but we've covered that. I think you all know where I'm coming from on it. But it's still worth saying that the reason we're talking about this is because the definition of the time listing would give a means to regulate a big part of the auction business that has moved online, or new business models have been established to offer competitive bidding online that are not currently subject to regulation. This would regulate them.
I do want to point out that it does just go back to the definition, that we have the statutory definition of an auction and an auctioneer. And the definition of an auction basically says it means a sale transaction conducted by means of oral, which would be public outcry, or written exchange. And I think an issue here comes down to when I enter in a bid online, am I entering a written exchange? And my belief is that I am, as a consumer and an auction consumer, and our belief as educators are that is true, that's a written exchange between an auctioneer and a member of the audience, which exchange consists of a series of invitation for offers for purchase of goods or real estate made by the auctioneer and offers to purchase made by members of the audience, culminating in the acceptance by the auctioneer of the highest or most favorable offer made by a member of the participating audience. And an auctioneer means any individual who, for a fee, commission, or any other valuable consideration, or with the intention or expectation of receiving a fee, commission, or any other valuable consideration, by the means or process of auction or sale at auction, offers, negotiates, or attempts to negotiate a listing contract, sale, purchase, or exchange of goods. So I think that when we're trying to clarify here is what really specifies a written exchange and how the internet plays into that.
So that's what the statute says now?
That's what the statute.
But it hasn't been interpreted as covering online.
Well, it's been in this. It has been interpreted both ways and not both ways. And I think, we can keep going back to that legislative session. I was there in that room when that happened as well. And as Mr. Allen pointed out, there was a lot of discussion at that point when that exemption came out that we all, just for ease, call the eBay exemption. It's not, just specific for eBay, but it was at that time. Because at that time, the only online auctions being conducted in the state of Tennessee were being conducted by eBay. And so at that hearing, there was a lot of discussion then, and that fixed timed ending was indicative of the auction process that was in place at that time, which is not the auction process that's in place now. And that's where the confusion lies. So my personal opinion is that to not clarify the timed listing would require us then to go back and redefine auction and redefine auctioneer. And those are pretty standard definitions that, with minor variations in language and clarification, are pretty standard across every state that regulates or does not regulate. So,
Will?
I agree with Ressa's understanding of the timeline. Back in 2006, when the exemption was put in place, the legislature at that time saw fit to exempt from those definitions that are well established, which they are, but the legislature exempted timed listings, and they did so primarily because of eBay at the time and their business model of having drop-off stores. But the decision to do that wasn't limited to eBay. It was done in a general way. And an entire industry grew up in that exemption, and since 2006 has prospered. And a lot of folks who had been in the traditionally regulated part of the business have moved to the unregulated part of the business. And the interesting thing that neither the commission nor the task force nor anybody has been able to demonstrate that that's harmed the consumers of the state of Tennessee, because the data's not there to support that. And so the question is, does the state having a reason, a compelling reason, to step back in and regulate a part of the industry that has been unregulated purposefully since 2006 when the exemption was passed. And the legislature has had the opportunity to do this, and most recently in the Joint Government Operations Committee. There was a rule that was promulgated by the Auction Commission and brought forth and sent to the Attorney General, passed through the Auction Commission, that defined what a timed listing was. And the legislature and the Joint Government Operations Committee neglected to approve the rule because they saw that the industry had grown up in the exemption, and that approving the rule would have a lot of consequences in altering the way that the businesses that have been successful working in the exemption, it would alter the way they would have to do business in the future. And the legislature didn't see fit to do that. And that's been, I think, the legislature's biggest concern has been that we as an industry need to figure out if we were going to be able to resolve whether there's a need to regulate online auctions or not. And I think this task force was intended to make sure that we had a good and ample opportunity to at least talk about that. And I think we have talked about it, but I'm yet to see a compelling argument as to how the public is harmed by the current exemption, and how it would be further protected by regulating a business that's currently not regulated. And so it's a big deal. It's a really big deal, and it gets down to philosophical issues of what you think your government should be doing. And I just don't see the harm to the public here.
Mr. Speaker, first of all, Mr. McLemore references an Attorney General opinion that he then wants to serve as the basis for the decision by the Joint Task. What's the name of the committee? The
Joint Government Operations Committee.
Right. What was the Attorney General's opinion? At that, well, it was my understanding that their opinion was that online auctions didn't, as they existed in 2016 when that ruling came down, did not fall under the eBay exemption, that currently soft close online auctions should be regulated. So to suggest that the Attorney General had an opinion and then to follow it up with, and then the Joint Task Force or the Joint Rules Committee said that they didn't, that it shouldn't be regulated, is to suggest that the Attorney General's opinion suggested that it shouldn't be regulated, when in fact it was just the opposite. The second thing I would say is, yes, there is very little data indicating public harm because the public is unaware of where to take the data of their being harmed. When they get in real terms, there is not an oversight of online auctions right now. So if they call the Tennessee Real Estate Commission and say, I had an online auction of real property and I need to know who to talk to because a bad thing happened, the Real Estate Commission is going to refer it to the Auction Commission. And then the Auction Commission is going to say, we don't have any oversight on that. Or they're going to get someone who works in the Auction Commission to say, it won't even make it to someone who can make that decision because we've been instructed not to deal with those matters. This is what this task force is about. And I think Will hits at a very fundamental issue, which we as the people being selected to be a part of this task force, he's hit it on the nose. Do we deregulate the auction industry, or do we have sensible auction regulation that conforms with the way auctions are being conducted in the state of Tennessee? And that's the question before us. And I think I know where I stand on that issue, which is I think it would be absolutely ludicrous to get rid of auction regulation, because regulation comes into play typically because something bad has happened to the consumer. At some point along the line, someone got screwed. And somebody said, we've got to do something about this. And because the auction industry is unique in that it can handle so much of a person's personal asset, inheritance, land, I just think that throwing the baby out with the bathwater for philosophical reasons is a bad idea.
I would just like to make one quick point, is that every auctioneer on this panel is currently licensed and regulated by the Tennessee Auctioneer Commission, including Mr. McLemore. So when Mr. McLemore talks about going into an unregulated industry, that is not the case, because the auctioneers, and including you, every time you renew your license, you are voluntarily submitting yourself to regulation for all aspects of your auction business. And I trust that Mr. McLemore is conducting his business in compliance with the laws that are in place currently. So it is not entirely unregulated. When auctioneers have gotten into the online auction business, they are still being regulated. They are still licensed. And I don't know of any who have given up their licenses in order to conduct online-only auctions to this point. And no, there are people out there who have not pursued licensure to conduct online auctions, but not nearly as many as there are licensed auctioneers who are voluntarily submitting themselves to ongoing regulations because it is the right thing to do.
Mr. Chairman, if I may.
Mr. McLemore first. He was first.
It's a matter of your activity. There's certain activities that are regulated and certain other activities that are not regulated. The bulk of my business is not regulated because it's conducted online. However, I'm not going to give up my licenses because there are two specific areas of Tennessee law that require me to conduct auctions at outcry sale. That's when I sell to perform a sale on execution for a sheriff and to conduct a foreclosure auction as substitute trustee or as agent for a substitute trustee. Those have to be done in person from a notorious location in the county between the hours of 10 and 4 during the week. And there's certain notice provisions that go along with them, but they have to actually be done by outcry auction and cannot be done online per statute and per interpretation of that statute by the governmental entities that oversee that. And I've asked them to consider whether they would allow for an online auction to take place there. Can't be done. So for that reason, I've still got my licenses. But as David mentioned, it's not a question now. It's whether we're going to conduct an experiment to deregulate the auction business right now. That happened in 2006. The question right now that is whether we are going to re-regulate the auction business and whether there is a public need to do that. And I'd say there's clearly not.
Ars?
The only way you can determine whether the public's been harmed or not is through complaints. And I do know that we do not hear complaints about online auctions because the staff has been told that if it's an online auction, we don't have jurisdiction, and so it's automatically dismissed. So we don't have it. The reason we don't have the data is because those cases, those complaints that come in are dismissed out of hand, and they're not even brought before the Tennessee Auctioneer Commission. So to say that there's been no harm, there's no proof one way or the other. You don't know if they have or they have not. So that's my point.
If I could speak to that. And this is posted, the information that I'm about to share, to the website. And I think in the previous meeting that we had, it was also in our iPads, where we looked at the number of complaints that we had that went before the Tennessee Auctioneer Commission. So there were, over the last 3 years, there were 11 consumer-generated complaints regarding online auctions. And of those, only 3 were about extended time. So to David's point, not a lot, which could be from lack of awareness, but we also do have some people that knew about it. And Jeff, to your point about them being dismissed before they even make it into the system, that would not be the case. So you might not be aware that we changed the way that we process our complaints a couple years ago, so that's not actually done directly at the program area, but that it comes in through a centralized source. So we take in all of them and then send them out for investigation. So they're not people aren't getting cut off and told this isn't the place to file a complaint. So on the whole, I would say that we're not keeping people out. It could be, to David's point, that some people aren't aware, but I would also point out that that could be the case for any program, that people don't know where to go. And we do have some who have filed complaints.
Chairman, this is our 4th meeting, and I think we've had 3 previous opportunities for public comment, and we haven't had anyone come to say that they were harmed by an unregulated auctioneer coming in and conducting an online auction with extended time bidding in the state. And it seems like this would be a really opportune venue for somebody who felt that way to come and voice their concern. They have not done that.
I think you're giving. Oh, I'm sorry, Mr. Chairman. I think you're giving way too much credence to the publicity of this meeting. I don't think anybody is aware that we're meeting so they can voice their opinion. The people who represent out here have vested interests because that's their business to have vested interests.
What I'm saying is, it hasn't crossed the threshold of being important enough to someone to actually come in and spend their time and effort to make sure that the state is overseeing it.
But if you think about that, there would be two types of people. There would be people who have had an auction and would have been wronged by it or righted by it or felt the need to do it, and the vast majority of people who've never had an auction. So it's sort of I'm not sure. I mean, I get the talking point. It sounds like it's an interesting fact that sort of supports a decision, but I would suggest that it's not.
Well, I think that it'd probably be much more likely that someone who felt that they were harmed by an unregulated auctioneer, or for a regulated auctioneer for that matter, might pursue what criminal or civil remedies were already available to them outside the auspices of the commission. And those are important to
Mr. Chairman, if I may, Ressa addressed that earlier. What were your facts and figures about the viability of a single individual seeking redress through the court system for a wrong of a small claims auction situation? What's the likelihood, cost-wise, that that's actually going to occur? Because that is a mantra of Will's side of the argument. They can just take them to court and sue them.
Civil litigation is exceedingly expensive. I
Yeah.
mean, you're talking about attorney's fees and $300, $400, $500 an hour.
Yeah, it's just not going to happen. It's not cost effective.
And as Mr. Lawrence pointed out, I think when I brought that point forward, is that even having an auction commission and regulation does not make the consumer whole. I mean, that is not the role of the commission, but it does give the consumer an opportunity to be heard. And in many cases, I think, that can also be a barrier to filing a complaint if they're looking to be made whole, if they're financially damaged. They know they're not going to be made whole by this commission. There are others who I think are glad to be heard that they have been wronged and that there was some kind of a punitive action taken against.
So how does that work exactly? If you regulated online extended time auctions and I was wronged in some way in one of those auctions, I would then complain to the commission, who would do what about that?
The commission, Commissioner Morris could probably speak to this better, but the complaint process gives the commission the authority to suspend a license, to assess a financial penalty to the auctioneer, and also there is a recovery fund, which we haven't really discussed. I think we're going to be getting to that here shortly. There is a recovery fund that, in the event of a civil litigation, damages can be reimbursed to a point, a small reimbursement. One of our recommendations is
that process
to
is pretty onerous in that you have to sue the defendant for damages. You have to win your judgment. You have to try to collect that judgment, and you have to fail to collect that judgment prior to any application being made to the recovery fund. And I think it's $10,000 per instance, and
which is why it's almost never done.
Right.
But Clark, to your question, the most common punishment would be a monetary civil penalty that would be enforced. Russ is right that ultimately the commission has the ability to take the license of someone for a wrongdoing, which is an extreme. That's usually not where the commission is, but it's generally with a civil penalty.
And it's within.
How would, Will, you kind of alluded to this, but the online auction business has developed in an environment where there hasn't been regulation upon it. How would those kind of reliance interests be affected by if all of a sudden they were now subject to regulation?
Well, part of the discussions that we've had in the previous task force meetings have talking about the reduction of the apprenticeship. It used to be, and currently still is, if online auctioneers were subject to regulation, then it would put governmental oversight well into the human resources departments of a lot of auctioneers, where you've got activities that anyone who's participating in conferences with clients, as per the definition of auctioneers, would need to be regulated, and that causes a lot of compliance costs within an organization. Typically, you've had folks deal with that by having a single auctioneer licensee, and then it's less clear as to what happens for the personnel that work as an employee of that corporation or of that entity, whether they're going to be licensed or what their activities are, based on what should be done per the definition of the auctioneer, and also how that would impact an online business being brought under regulation will have a lot to do with whether the decision to regulate online auctions based on whether they extend their ending time was paired with a reduction in some of the requirements that are currently in existence. So if you just said, if the bill went before the legislature and passed, it said if you happen to run a timed listing that with an extended time bid, then you are subject to the auction regulation as is without any other change, it would be pretty onerous because right now an auctioneer can only have 3 apprentices at any one time, and those apprentices have to serve for 2 years before they can get through that process. And so it would limit the growth of the business and cause some difficulties in staffing and in job descriptions, and it would come with a commensurate increase in cost. The only way to deal with those compliance costs would be to pass them to the consumers.
Mr. Chairman, if I could address our only public, because he is who we're trying to educate and protect here. I would be curious to know, other than Macklemore Auction Company, what a lot of auction companies that would be affected by this would be. In terms of the thing. That's more of a rhetorical question than an actual answerable one. But one of the reasons that we're doing this and why we are changing this is so that businesses who currently operate and have a number of different what you would call apprentices could continue and have the ability to grow those, which is why we did not place a number with the new task force suggestions. So someone like Will's business model could hire as many affiliate auctioneers as they wanted to, which was a concern and a concession to his business model, which we felt was necessary in order to refute the fact that if we're going to regulate this is going to hurt me because I'm going to have to, I'm going to be constrained as to how many people I can hire. I just can't help but go back to the fact that I'm just not sure as many business models or businesses that Will suggests exist being affected are as many as it is.
I have one example in particular that is an interesting case. Everything But the House is a pretty large internet-only auction company headquartered in Cincinnati, Ohio, where they employ, I think, several hundred individuals to carry out about their business. And at one time, they had an office in Nashville with 12 employees in it, which they since closed. And one of the reasons that Jackie Denny, one of the principals of Everything But the House, one of the reasons she cited was regulatory uncertainty. Because even though she had a Tennessee license, it was unclear to her whether her employees here would have to have Tennessee licenses in order to continue carrying out the business that they'd been carrying out since about 2006 when they came to town and began to operate. And so we no longer have those 12 employees operating, contributing society here because of Everything But the House business. What they've done instead now is they source goods from those who need to settle estates, pack them into trailers and haul them to Cincinnati to be sold and then shipped out from a central hub. And that's been a loss to the state of revenue. And so there's a tangible case that has been the regulatory uncertainty and the attempts to regulate online auctions have already had an impact in the marketplace.
And conversely, that same company that you mentioned, another reason they left was because of the number of complaints that they had received for their bad business practices. That's another reason why they left the state, because they thought, we've tried this experiment here in Tennessee. It looks like they're going to try to regulate us. We're not doing well. Let's go find other easy pickings.
I also do want to point out that all of those onerous points that you brought out, Will, are points that we have addressed and approved in these other documents to make it so much easier. So even in the case of everything but the house, this would open the door for them to come and bring those jobs back to Tennessee if they decided to do that. It makes it much easier. I'm with the recommendations that we've already endorsed. It makes the entry is so much easier for people to get into online, so that more people can, with that responsible party, can then bring in employees who can then go out and discuss contracts and meet all of those other points. So under the current laws, yes, it is restrictive, and I think that we've done a really good job in lightening those restrictions, which I think was one of our primary.
What we were tasked to do.
What we were tasked to do, and I think at this point, under the umbrella of those recommendations, it's very easy now to come in and vote on this definition of a timed listing, because it doesn't create the umbrella is no longer restrictive for internet auctions. They can get in relatively easily. They can designate a person. They can get requirements. They can pay their licensing fees to the state, and it can happen relatively quickly with minimal invasion into HR departments. And ideally, every HR department is in compliance with federal and state laws anyway, so even if somebody's looking over their shoulder, it should not be an issue. I would like to...
Mr. Chairman, I just wanted to say something about the complaints, about everything but the house and the complaints. I'm sure that there are people that complain about their business, but I don't want to allow for the potential misunderstanding to be the complaints that Dave is talking about are the same complaints that Clark was talking about in his list of complaints that were formally filed with the Commission. It is very possible, and it's another thing that's definitely been on my mind as we've discussed this. It's possible to find complaints about any business now. It's easy to do that if you go online, and if you have a complaint to voice against a business, social media is an excellent outlet for that, and it's something that was not in place when this regulatory regime was initially implemented. And I don't think I think it's important not to ignore outlets for redress that may exist outside of our legal system, because if you voice, I operate my business in terror of a civil suit coming from someone, whether they have their case has merit or not. It's still an expense to my business, and so that is something that I think about every day of the week. The other thing that I can't do anything about is when someone puts a complaint up on Google about my business that says I do bad things, whether they're right or wrong. I can't do anything about it, and so I have to go in and outperform, hopefully to the point where someone's going to give me a counteracting positive recommendation online, and that motivates me every day. Those are two things that it's really important to remember in this discussion.
I just want to say one last thing regarding EBTH. One of the reasons you don't have formal complaints is because no one knew who to complain to, because they weren't regulated.
Can we just make a motion to either approve this online auction definition?
Yeah, I was going to make that motion now.
I would like to second that motion.
Well, let me go ahead and make the motion, and you can second it. That way we'll have it in the record. I would make the motion that we approve and define time listings for the purposes of the exemption in 6219-1039 as time listings means offering good for sale with a fixed ending time and date which does not extend based on bidding activity.
I second that motion.
Any other discussion before the vote? All in favor say aye.
Aye.
All opposed? Aye. One opposed. Motion carries. Now, yes, sir.
On the second bullet point,
Mr. Weaver, I'm having trouble here. There you go.
I'm sorry. 5517-120D talks about the auction of salvage vehicles, non-repairable vehicles, or a combination thereof. That's what this bullet point relates to, but it talks in terms of automobiles. So that clarification, I think, either needs to be inserted if we're giving this to someone to try to draft, or the other way to say is nothing shall be deemed to adversely affect 5517-120D, which was a statutory scheme that was worked out with the parties, which covers their business models. And so in that, there's two licenses I think they have to have from the Motor Vehicle Commission. What the auctioneers determine they want to do is fine. But we need to make crystal clear to the legislature and anybody watching these tapes that we're not adversely affecting what has been on the books and which is a business model for several people, I think, in the audience.
What would be the most
I'm
effective?
a
clean it
belts
up?
and suspenders kind of guy, as Clark knows, so I'd do it both ways, you know. I'd insert exempt online auctions of non-repairable vehicles, salvage vehicles, or a combination thereof by companies engaged in the auction industry holding a Tennessee motor vehicle license issued by the Tennessee Motor Vehicle Commission. Nothing shall be deemed to adversely affect TCA 5517-120 subsection D. That's about as clear as is that all right? That's not all right?
Mr. Weaver?
They want to hear some public comment.
Right. So in our auction model, we would still receive vehicles that may have a clean title. Those would still be business-to-business transactions, have nothing to do with public-to-public transactions. So I think limiting that exemption to just the salvage and the non-repairable would cause us to be regulated under if we had to sell a clean title vehicle.
What if we just made it subject to 5517-120D? We'll take the belt off, leave the suspender, and go with 5517-120D.
You're going to make that in the form of a motion?
Make that a motion.
Second.
Any discussion on that?
Comment?
Comment from the, yes.
Mr. Chairman Gary and members of the task force, I'm Tony Thompson, and today I'm representing IAA, Internet Automobile Auctions, and we're very much interested in this language just as Copart is interested in this language. The one difference between our two companies is we conduct a simulcast live auction at the same time as an online auction. So this exemption that you're considering right now will only cover them. We're the only two companies in this business. And what we do is sell total loss vehicles on behalf of insurance companies to licensed dealers, dismantlers, rebuilders, and scrappers. We do not sell to the public. And our auctions are timed. They do have an ending time. But we're currently regulated by the Motor Vehicle Commission. We have two licenses from the Motor Vehicle Commission. We have the Tennessee Auto Auction License and the Tennessee Motor Vehicle Dealer's License. If we hold, if one of our auctions involves a live auction at the same time as the online auction, there's always a licensed Tennessee auctioneer that's hired to be there. And so we feel like that it's unnecessary for us to have this double regulation, if you will, to have 2 licenses from the Motor Vehicle Commission, additional licenses under the under the Auctioneers Commission, and would just request that we be added by the addition of certain language. Just a few simple words could add us into this exemption as well.
I have a question for you, because it seems to me, because you are licensed under the wholesale auction license, that license requires you to use a licensed bid caller, or auctioneer at that point. But wouldn't you also then be exempted under this, because that is exempt under regulation of your sale transactions? Just requires you to use a licensed auctioneer, just like a wholesale auto auction. It seems to me. So I need clarification on that.
I don't think so. I think the language that you're considering, and I actually don't have that in front of me.
Okay.
I would love to see a copy of it, but I believe it says online, just simply online. And so we would just like to insert, even the word primarily online would cover us. We don't see that there's a justification for a different regulatory scheme based on the method of sale, since we do the same thing that Copart does, although we just have folks can be there live as well.
If I could, I believe this exemption would exempt most of your business model. What it would not exempt is your actual bid caller, which would then have to have a bid calling license. So I don't necessarily think we're double regulating one and not the other, because our business model, we don't have that bid caller per se. We are strictly online, so we wouldn't have that additional regulation to have somebody licensed as a bid caller. So I think your only regulation would then be, if you're going to continue to have that actual bid caller, he would be regulated, or the company would have to have him as a licensed Tennessee bid caller.
I see Ms. Hanson looking at me.
Yeah, could you
Currently
speak to that?
under 5517-120, both Tony Thompson's client, IAA, and Ms. Young's client, Copart, are covered by that statutory reference. The 5517-120D covers you right now. And so that was the question Ms. Hanson wanted me to
Correct. And I'm sorry, is it
Brad?
Gentleman Brad, his comment's correct. I mean, if we have a license, if we have an automobile, I'm sorry, it gets confusing. If we have an auctioneer present during our live auctions, of course they're going to be licensed auctioneers. We're talking about the business IAA being required to hold an additional license under the Auctioneer Commission. So we're just seeking the same exemption that they're seeking here. If we have a live auction, a licensed auctioneer will be there.
And again, my question is, and maybe Mr. Weaver can answer this, that is covered under that wholesale auction license through the Motor Vehicle Commission, is it not?
I think the struggle is the words on the draft that's in front of everybody that says online.
I see. Okay.
Correct. That's correct.
It's not in the existing statute.
Okay.
So the question is online and simulcast or online? Isn't that kind of the crux of it?
Yeah, that's exactly right. They're online, we're online and simulcast.
We hear from
Mandy Young with Copart. I think there's a distinction for Mr. and I think Ressa was trying to get there, in that because they have a simulcasted auction, it is conducted pursuant to the live auction that is at their facility. Copart's system is totally online. There is no simulcast, so there is no bid caller or live auctioneer involved because it's all online. Theirs is a simulcasted auction with the online capabilities added onto that. So whether or not this study committee exempts them, the bid caller or the live auctioneer would still have to have a license. So I'm not really understanding what what Tony is trying to get to, because we're not getting we don't have a simulcast. Copart doesn't. It's totally online and computerized with no simulcasted live auction anywhere on a facility. Did that help answer questions? So I'm confused at what exemption he could get that wouldn't require his simulcasted auction to still have an auctioneer, like your live auction would have an auctioneer.
My question is, does he already have an exemption?
He has an exemption, Mr.
Motor
Weaver,
vehicle law.
under the motor vehicle law for that. And the exemption that you've discussed would not require us, because we have a motor vehicle dealer's license, to obtain an auction license in addition, because we don't have that live auction in a facility where there's an auctioneer that can choose Ressa over Carter. Okay? The online process is protecting the consumer in Copart's mind so that there's no human error or human person to pick a winner and a loser. Okay, which prevents some of the complaints that I think your body's been talking about. And I'm happy to answer questions or. Addison wants us to take a recess if the commission would be so willing.
Let's take about 10 minutes then, right quick. Wait a minute. Wait, before we do that, Mr. Thompson wants to follow up before we do that.
Yeah, I just want to say that again, it's not about protecting the public in this situation. We don't sell to the public. If this exemption, if this language goes in as it's proposed, that just says simply online and doesn't include online or online and simulcast, then, you know, in order to get the same business exemption from the Auctioneers Commission, what my client can do is cancel the live auctions and stop hiring Tennessee auctioneers in 4 cities across the state once a week, you know, to get the same regulatory advantage that their only competitor is getting. So we're just asking for a couple of simple words to be added in, to be treated equally.
Let's take a 10-minute recess. So what he's saying.
Clark, you got a lot more than you bargained for, right?
Yeah.
Yes. That's one question.
This exemption is from the auctioneer's law.
So that was my question. Is you take.
Yeah, I did. Did you travel anywhere?
No, I've got out-of-town family who came in. So we got to see.
I was trying to stay out of the way. For us to hear their understanding of how we'd like to proceed with the addition of a few words, I think, to the direction of the task force.
Thank you, Mr. Chairman, members. Tony Thompson for IAA. As I understand it, and I still have not seen the proposed language, but with a minor tweak to the language, I believe that Ms. Young and I are in agreement with what both our goals are, and that is that we would both be exempt from the auctioneer laws in terms of businesses. But in my case, if we have a live auction as a component or an in-person auction as a component to our online auction, then we will be required to hire a Tennessee licensed auctioneer. And we certainly agree to that. We've always agreed to that.
The only thing I would add to your knowledge is that on behalf of Copart, Mandy Young, part of the reason that you've documented and you've agreed potentially to this exemption is there is a license and regulatory scheme that oversees these entities, because Copart and IA would still have to have a motor vehicle dealer's license. So to the point of the commission, they would still have some entity in the state of Tennessee still has regulatory authority over complaints and concerns about this to protect the public public in your minds. In addition, there's only a slight difference between the two entities, as you've explained. One is a total online business, and another has a component of a live, in-person auction that people can be in present, and therefore those individuals would have to have an auctioneer's license if they're conducting an in-person auction under Tennessee law. This proposal.
Mr. Chairman, and just so we're clear, you're talking about business to business for the live in-person component. That's Tony.
My client is only business to business.
Okay.
We don't sell to the public, period.
And your client is a licensed motor vehicle auction.
Correct.
Yes,
By the motor
we're
by
a
the
motor
motor
vehicle dealer. We are
Uh-huh.
not a public automobile auction licensed under either the Auctioneer Commission or the Motor Vehicle Commission,
So there's
because
a
they do not take title.
Right, but there's a motor vehicle dealer's license,
Correct.
and then there's a motor
Auto
vehicle
auction.
Auto auction license.
Auto auction license.
Yes.
And
We have both.
okay,
I don't,
We have a motor vehicle auto auction license under 55.
Make a motion, we adopt. And the motion would be that you want to say that both the exempt the from the auctioneer's law, an online and an online with simulcast, as long as they're if there are live in person participants, a licensed bid caller will be used. Am I using the terms correctly in your law?
can we specify that it's also that they're not just regulated with as a motor vehicle dealer, but they're a motor vehicle auto auction
Automobile auction
license?
is the license name.
Right.
once you have the language, I guess I would really appreciate it if you could share the language or read the language to us before you take your final vote. If somebody.
Do you anticipate that this exemption would have a provision related to the size of the business or the way it's financed, if it's publicly traded, or any? So if you were opening up a automobile auction firm, you could pursue the same exemption without having to be publicly traded or have anything
Those
else?
words, Will, were taken out of the latest draft, and I think it just says an online auction company with a license under 5517-120.
So technically, you could be a startup, and you could be a sole proprietor and take advantage of that exemption.
You'd have to otherwise qualify for the license.
Right. I mean, if you could meet the qualifications of the motor vehicle dealer's license, essentially, we're not privileging a large corporation here. That's what I'm trying to say.
That's correct.
Okay.
That's correct.
All right.
So can I take a stab at maybe what this would read as here?
Can't wait.
I know. We're going to take a stab at this. Okay. But I'm going to ask Mr. Weaver for the code number, but exempt online auctions of automobiles by companies primarily engaged in the wholesale.
Well, no, ma'am, I have to stop you there
because wholesale
you
is not. Does
you
not
need to track 5517-120D.
5517.
Because that defines the type of vehicles that can be sold, to whom they can be sold, and if a dealer's license is required to buy.
Okay, so exempting online auctions of automobiles by companies regulated under 5517-120D and holding a motor vehicle
The appropriate
motor vehicle licenses.
No. Mr. Chairman, if I might, could the lawyers get together rather than doing it the way you have exactly worded it? You are narrowing it much further than we had intended. So if you'll let the lawyers get together and wordsmith it following what Mr. Weaver suggested, that it's tied to 5517-120D.
Exactly, okay. That would be
Rather
fine.
than narrowing
Yeah,
exactly
no,
what
I-
can and can't be sold,
Yeah.
we would appreciate it.
Yeah.
And to Mr. McLemore's point, it will not help one company over the other. It will be open to anyone that conducts the online auctions in the way that you've discussed.
So for the purpose of us approving this to go forward is allowing there to be an exemption for motor vehicles that are properly licensed under 5517-120D. Is that, and allowing that language to be, how do we word it to move forward as a
How do we move
task
to
force?
approve it?
To approve that.
I think the original language was tied to online auctions
Automobiles.
that had a motor vehicle dealer's license, and Mr. Weaver asked that we tie that motor vehicle dealer, or authorized or regulated under the motor vehicle section, and we'll tie that to 5517-120D and leave it at that.
So this original language tied to, specifically
Tied to 5517-120D.
So this language says exempt online auctions of automobiles by companies primarily engaged in the auction industry holding a motor vehicle license.
Appropriate motor vehicle licenses.
Motor vehicle licenses. So that's what that language says now. So if it's tied then to 5517-120, all I'm trying to do is get it to where we can move forward.
We're not going to have language. None of this is in writing today, Tony. It's all proposals that they are voting on in proposal language. Nothing's in writing.
Okay.
Firm writing, that is, I should say.
I guess I am interested in what you vote on ultimately, obviously. And Bob, you know the devil's in the details, and so to follow your notion there, Ressa, if you could read the proposed language right now as you think it's going to be considered or voted on, that would be helpful to us in the audience.
Take another stab at it. As a task force, we're recognizing an existing structure that's found under 5517-120D, and that has to do with the sale of certain vehicles, primarily business to business, and I say primarily, don't fall out, because there is an up to 5-person exemption, and it's going to say that whether you're in 100% online or if you're primarily online but also have a simulcast feature for in-person bidding, that your regulation is going to fall under 5517-101, and that as long as these parameters are kept and you hold the appropriate licenses from the Tennessee Motor Vehicle Commission, so that you're regulated and there is redress if there's problems, then those, with the exception of the live in-person participation, in those cases, a licensed Tennessee bid caller will be utilized.
That was very close. Mandy Young again on behalf of Copart. I think you need to distinguish, and we can when we have a computer and a piece of paper and everybody can agree to it, that it is not, the live auction is going to have, or the in-person auction is going to have regulatory requirements under the auctioneer law for the bid caller to be present. So all that this would do is provide an exemption for anyone selling under 5517-120D, but they may sell other items beyond what they can sell under 5517-120D as well. That's my only distinction, but it provides a recourse through the Motor Vehicle Commission.
Tony Thompson, IAA. I'm sorry, I guess I want to clarify that distinction that Ms. Young mentioned. The live in-person component, regulatory, the regulation from the Auctioneer Commission would be over the licensed auctioneer conducting that. In other words, all regulation is under the Motor Vehicle Commission, but for a licensed auctioneer who's present at an in-person event.
A second.
I got one thing I'd like to say.
Yes, sir.
While we're in the business of eliminating dual regulation, we really ought to just consider handing over the auction commission's regulation of real estate auctions to the real estate commission by the same logic. Because that's what this is doing. And there's something to be said for that. Dual regulation creates confusion as to which body is in charge of actual regulation here. But it makes it clear that the Motor Vehicle Commission should be regulating the sale of salvaged vehicles at online auction. We could do the same in the real estate auction business if we wanted to. But that logic is what we're using, and I'd like to call it out.
Any other discussion? Question's been called for. All those in favor, say aye.
Aye.
All opposed? Motion carries. All right. I think we've had public comments, I assume. But we've got a couple more things, down here, I know.
There's 4 more
I'm
things
sorry.
that we've got to go through.
I'm sorry.
Mr. Chairman, just real quick, I just wanted to point out that Mr. Wood isn't here. To Will's point, it would be helpful before we had any kind of discussion about that we had the representative from the Real Estate Commission be here, and he's not here. So, just want to point that out.
The next point that was in our red line document was talk about switching from the recovery fund to a surety bond. I personally would like to withdraw that recommendation from this. I think some others talked about it, but I don't want to move forward from my point of view. I think the recovery fund is working fine the way it is, and to switch to a surety bond would be, I think, more expensive for the licensees over time. So I'd like to withdraw that, unless anybody else wants to do.
I have to say that if we're here to discuss what potentially could harm the public and create an ability to redress those harms, I'd much rather be somebody who is trying to seek payment out of a bond than I would out of our recovery fund.
I know that the Tennessee Auctioneers Association did get behind that change to switch to a surety bond, and I do think it would be easier. I mean, you pointed out how difficult it is and how rare that is of an occurrence. So I can see your argument that it's in place and it's less change. And I know at our last meeting, I wish Carter was here now. He had mentioned that he would bring some information to us about the cost, and this may represent a cost that may have a cost factor to the state, because I know that the licensing fees that pay into that gets to be a complex kind of thing. So, in that regard, I can certainly understand your point. On the other side, I am going to agree with Will that it probably would be easier for a damaged party to receive compensation from a bond. I don't think bonds are terribly expensive, and a lot of our reciprocal states do use bonds. There are more states, I think, that use bonds than recovery funds, but different states go different ways. So, just to throw that out as talking points.
Mr. Chairman, I'm curious. You mentioned cost. Anybody have an idea about what a $20,000 bond would cost for an auctioneer? $100 a year. And then what other bond requirements can you think of would most likely be needed? What, other than just make a payment? What do they typically do?
Oh, you say I need to get a bond, and they send a bond out, and they send you a bill for $100,
and that's it. That's it. They don't.
You don't have to qualify for it.
Okay, I was going to say there's no. We've got a guy coming, and we want to look at your tax records for 50 years or something like that. Okay.
No, if you pay the premium, they're going to issue the bond.
Gotcha. Okay.
If something did happen and you had a claim against your bond, you might find it much more difficult to get one in the future.
Next time. Right. Gotcha.
So
you got to have a clean record.
You got to have a clean record. Yeah. That's good. Okay.
Now,
and I will say that the Education and Recovery Fund, we've got over the $250,000 minimum requirement already in. We do use some of those funds for educational purposes as well as. So I think there's some additional benefit to the way it's set up now. That's the only other point I'll make.
If we could, do we know if Carter is coming back? I mean, his notes are all here. Okay. So can we
roll
defer
this?
discussion on that until maybe he gets back, because I think he would be
That's
valuable
fine. We can go to the
input
next
into
item.
that.
Talking about on advertising.
Removing the requirement for a firm license. Well, if we're doing away with the firm, it looks to me like
Right,
that needs to be
right.
deleted.
Yeah, we're talking about getting rid of the firm license and the gallery license, so those two kind of go hand in hand, and so I would move that we do that.
On
Mr. Chairman? I'm sorry. Go ahead.
Okay. On the gallery license, I think similar to David's concerns about grandfathering, if we do away with the gallery license, how will that look for current gallery license holders or people who are actually
I
in
think
the
what we'd have
process?
to say is if you had a current gallery license, and so long as it stayed in good standing, that it would continue to be a gallery license. There would be no new gallery license issued, and that you would have you'd be basically grandfathered in as long as you're in good standing and kept that license current.
Okay. And
I don't know that, from my viewpoint, if you've got a logo that you're using, there's nothing to say that you can't keep using it.
Yeah.
And that kind of gets me. It says, but require the name of the business and the name of the responsible person and telephone number. We may have some people out there that have, Joe Six-Pack Auction Company that don't have the responsible person on there. From my viewpoint, I think just the firm number removal and let them use what logos they've been using for some of them for years and years and years.
Again,
You have a problem with that information?
I don't have any problem with that. The main thing we're looking for is a person that we can point to for being responsible
Right.
for that firm.
Right.
That's the whole point of this.
So, Mr. Chairman, that begs the question, moving forward, I just think that there's some legitimacy to the concept of some type of license number, be it the responsible party's license number or the old firm license number or whatever. I'm in agreement that if you've already gotten your logo out there and it's got that kind of information on it, I don't think you should have to pay to redo your logo to meet additional requirements. I'm trying to think if I've got my name on stuff. I know I've got the company on it, but I don't have my name, which means I'm going to have to go back unless I'm grandfathered in. But I do have my license number on there. So I think we might want to make some provision that says if you're an existing auction company as of such and such a date, then there's an assumption made that you've got your firm number on there, and then everything else is about doing business, the phone number and all that. But as Jeff points out, we need to have something in my opinion, we need to have something on the sign which identifies who's responsible. And so moving forward, I think a name is important. I think the person's name is important.
And a number may be fine, but it just removes the requirement this says of the firm number, because
Right.
you're not going to have a firm anymore.
Right, and I don't have a problem with that. But am I going to have to go back and change all my signs to say, instead of Music City Auction, Tennessee license number 4976, to say David Allen, license number 5600?
I don't think that's what this is saying. It just says remove the requirement. If you want to keep your firm number on there, that's on there.
Well, but I'm
forever,
not. But the responsible party can be a business then, not a person.
the responsible party, because even the business has to have a responsible party. So yes, somewhere you would have to have David Allen's
That's what
name.
I'm saying. So I need to go
right.
back and redo my signs.
Yeah, and there may be a grace period. I don't have a problem with a grace period for, you're ideally going to replace your signs over a period of time anyway, but
Try
at
not
some
to,
point.
but
Yeah, but, that speaks to a good point, is that a lot of auction companies already have their firm license numbers on their signs.
Right.
But when we add an ad to a Facebook campaign or in a newspaper, we are putting in that firm license. That's an easy change to put the person's name. So I don't know. We don't want to cause something that's really cost prohibitive to a company to, like you say, have to go out and buy all new signs. I agree with that. So maybe it's putting the name in print advertising for a transition period.
Why can't we just put the business name and not, because we may have premises and, I mean, I think you need the business name and phone number is what you need.
Well, yeah, I mean, as I said, this sounds like an easy fix, but
Could get complicated.
It could get complicated in terms of what's going to go on the sign. If I understand correctly, the purpose of having the information previously on the sign was to let the public know that this theoretically was a licensed company that had attained a Tennessee license number, and it was on the sign. Just like a lot of other businesses have to say that they've been licensed as an electrician or whatever. It's certainly a selling point in an era of unlicensing. I mean, that's why I'm going to keep mine on there. But going to Jeff's point, if we're saying we need to have a responsible party or person, I think does it say person or party? My thing went blank. Person. So now we've got to add a name, which I'm okay with that, because that's just, but what do we want? So once again, and now this goes to your point, James. You're sick and tired of people turning in other people because the Tennessean forgot to put your license number on there, and it's a petty thing to do. So where is our answer here? What do we want on there? What kind of time period are we going to allow, or grace period or grandfathering period for people who are already in business? And moving forward, what are we expecting of new people?
Well, and the other thing that you're seeing a lot of these fly-by-night companies come in town, throw up an auction. You don't know if they're licensed in this state or not, who the people are.
Right.
It says, they think it's some sort of a big auction. It's really not. It's really more of a sale of their stuff. And so, again, to try to get around or to have it easier for the public to identify who is doing this auction.
Right.
We would have a responsible. You can be Music City Auction. It's got to say David Allen and the phone number, and that's all we're saying.
Yeah. No, I don't have a problem with that. I'm just saying.
Well, what I'm worried about is the hundreds of guys out there that's got signs and stuff. What if we said remove the requirement for a firm number, but require the name of the business or the name of the responsible party? So if Morris Auction Group has got 80 signs out there, you don't have to toss them all and get new signs made. That's what I'm trying to think through, Jeff.
I get it. I mean, and I think we could have a grace period of break-in period or whatever you want to call it. But again, we're trying to get it to where
everybody has to do the same
we're looking at when we're the ones that sit on the commission. Who is that responsible party that we're going to point to? Who does that complaint need to be filed against?
I agree. I mean, if Morris Auction Company has the name of a business that's not a licensed business, then you still have no information. If they have Kenny Phillips' name on there, at least you have a name.
Right.
And so to prevent that from being cost prohibitive, I am all for giving even a 2-year or 3-year transition period where either a firm license number or the responsible party for a period of time, but effective on such and such a date that the responsible party's name.
Those are all good suggestions.
I know, like on a company sign on your building, I don't know if you need to have David Allen's name on that sign. And I know that our rules do specify signage on a building, but for an auction-specific advertisement online or in a newspaper or in a pointer sign or a directional sign or some banner that's hanging out there, then I think that the name is critical.
Mr. Chairman, and remember, once again, to go back to the role of this task force, it's to make recommendations. We don't have to have, once again, as devil in the details. We can come up with something that makes sense that can apply to those of us in business currently and those who are going to join the auction profession moving on, with the idea of making sure that a responsible party is easily found, because I think that's what we're trying to get at.
Right.
It's the folks that are not going to be licensed that are trying to put something over on the public that are going to be hard to find anyway, if that's the case, and that challenge exists whether they're it's a problem that exists. And if are you doing a Twitter post where you have to take up a good part of what you're putting on Twitter with all the regulatory compliant language, where you don't end up with enough to even tell anybody about what you're selling? It's problematic. But it seems like you could be able to have one place where you could find it, maybe in your terms of your sale or something, or something that could be limited to, so that you could comply without having to defeat the purpose of some of your advertising.
And I'm not sure I'd like for us to come up with some type of a motion which simply says we're going to look at all this, and as we get closer into it, because I think Will's right. It's hard to, theoretically, aren't you supposed to have your license number on every single electronic page that someone could stumble onto? I mean, I think that's.
I know the Real Estate Commission specifies it has to be one click away.
Yeah.
So
we look at. So we just maybe we can make a motion which says updating and revising current public announcements of responsibility and ownership of the auction firm or the auction license or something like that, and not be so specific at this particular point in time.
That one click away might get us there, because everybody hopefully be putting their website on their advertising.
Right.
And then if you got it at the footer of your website, then that's good. You're good. You're findable at that point. You don't necessarily want to link it to your phone number, because a lot of people use tracking phone numbers for different advertising. So if you're running in one print media publication, you might have one telephone number, and if you're running a different one, you want to know if you got different interactions coming from different places.
So how would that translate, Will, into print ads if we put an ad in the Tennessean or a sale bill?
The one click away, because if you got your website on your print ad, that's a click to the website. You might have to type first before you click, but that's your one click away.
The auctioneer who is not online, because there still are some,
and
it has to be on.
I'd say that
right
if they want to make it where they can write their responsible party in the ad, I guess at that point.
We say that we could make it immediately visible or one click away.
I just think we don't try to solve that problem today. We recognize that it's something we want to address in our recommendations to the task force.
It may be that if the task force, if the recommendations are to not do away with the firm number, then the firm number may need to stay on all the things. So basically, we're going to take no action on that for the time being?
Yeah. And whatever legislation comes up, we all have the ability to talk to the people who are going to be crafting the legislation. We can suggest, make suggestions and that kind of thing.
I would like to take action on it, and just even in a general sense, and say that we want identifying that this task force is making a recommendation that clearly Okay, I will make a motion to suggest that we move forward with clearly identifying the responsible party in all auction-related advertising, whether it is immediately available or one click away.
I'll second that.
Any further discussion? All in favor?
Aye.
All opposed? Okay. Now, since Carter's back, have you had a chance?
I just asked Dustin to go
Okay.
fetch my laptop.
Okay.
Right.
So I still have another question about the gallery license, which is the next point down.
Let's go.
So we talked about grandfathering, establishing, kind of a grandfathering around a gallery license that's in existence. If an existing gallery wanted to elect to change their gallery license status into a business license, would they also then be grandfathered into that? They could just make that application. They would have they have the education in place to get the gallery license.
I'm fine with that. But
so I think we just need to clarify
that person who is going to hold
to
that
identify the
business
responsible party.
auctioneer's license. Mm-hmm. And a lot of times the gallery owner is a non-auctioneer owned
Correct.
facility. So unless he wants to become an auctioneer under that B license, a lot of them don't. But
B license does allow for a non-auctioneer to get that business license and identify themselves as a principal, as the responsible party. So, so
They would
my
have to
question
have
is,
a B licensed
right, just by
person
making application.
as the operator of that.
Would they have to re-educate? No. No, okay. So I just wanted to get some clarification on that. Yeah. Satisfies me
Okay.
on that.
He's got another bullet point down here. All education can be conducted online.
I do want to speak to that. I want to make one exception to that. I do not think that the bid calling education can be conducted online.
I agree with that.
And so I would say all education except the bid calling component.
All right. Is that a motion?
I would like to make that as a motion.
Second.
Any further discussion?
Why not bid calling? Skype?
Skype, it's cost prohibitive, isn't it, from an educational perspective?
Okay.
And because most auction educators do multiple states, and some states are not going to be here yet. I just think that it's more of a hands-on learning thing. We've got that down to a small number of hours. It could be done in a few days. So I just think that's more interactive, and the bid calling instruction because
You sold me.
Yeah. It just doesn't make sense.
Yep.
I'm sorry, just for everyone else to know. I was asking for clarification. I understand you wanted some financial information, and I can look to see if I have it or get one of my fiscal people to get it. But what information did you
We're
need?
looking about switching from a recovery fund to a $20,000 bond, which would cut out basically.
That would
would
be.
be.
Sure.
You
Okay.
had mentioned at the last meeting you would have some financial impact information at this meeting. So
I'd forgotten
that was it.
Okay.
But I think we do have a
He didn't
motion.
get his homework done.
We have a motion on the table about the
Right.
education. So if we could just call the question on that one real quick and be done with that, we can get back to it.
All in favor say aye.
Aye.
All opposed? And we can give you another minute or two because we can run down something else here. Sure. Current license would be grandfathered in to match the new standards. I think everybody was just wanting to make sure that that was in place so we left nobody hung out to dry, so to speak. Anybody have any more concerns or questions about that? I guess do we need that in a form of a motion? Probably so. All right.
Few issues around governmental sales. Part of it, for clarification, there's
Okay.
a statute out there that exempts governmental sales from auction regulations.
Right.
And as I understand it, that would be not only judicial sales, but other sales of surplus property, or as long as the
Government.
selling and there's a separate statute for reverse auctions that's never been discussed in here, which allows a governmental entity to say, we're looking to buy these goods or services, post that like a bid requirement out there, and then companies can bid in, say, well, we can provide it for this, we can provide it for that. That's not regulated
Still
by
under
us.
government, right.
Okay. Then the third thing, this is actually something Mr. McLemore raised earlier. Didn't know if you would be open to including a suggestion, and I can't document all the statutes today, but there's a lot of antiquated laws out there that require certain sales by the sheriff or a court clerk to be done during certain limited hours upon the certain location, sometimes even at the courthouse steps, so on and so forth. That it's not about auctioneer licensing, but it is a barrier to some of the types of businesses that can be done, or the methods as to how they can do that. And some court clerks have expressed an interest in having more flexibility to use online or to go to different. Well, that we modernize those statutes.
We've been tasked with that.
I don't think they fall under the auction laws. Okay. That's the only one that comes to my mind is that if a sheriff requests any auctioneer to provide a lot list, that they have to comply with that.
I think specifically we're talking about the sale and execution statute, which is not technically in the auction statute, but it is an auction law. I guess it depends on how you interpret that. But that would be you could recommend that the sales on execution be reviewed in order to include online only auctions. That would be very welcome.
Certainly take that forward as a recommendation from this task force to review those to make sure they're still relevant to.
Further, you could look
these
for
changes.
the sales, trustee sales or judicial sales. I think that's the larger heading of the statute itself, where you'd find the sale and execution, but judicial sale statute, if you could review the provisions for auctions that are called for there to make it clear, because right now it's not clear that you can or that you can't, but that you could do those online only, or online with the simulcast, depending on your business model.
I don't think it's any problem with us making a recommendation, if we weren't tasked for that, if somebody would like to make a motion to that.
I have one question. Who are we tasking to do this?
The state legislature. You talk about the whole general force itself while we're here.
Oh,
Or his recommendation.
Just, we're getting outside the bounds of what we were presented with.
I see.
And I'm just saying, I'd suggest people want to think through that before you ask them to go into a statute. I know David pretty well. David, I think you'd probably want to take a look at that and kind of get it the way you think it ought to happen rather than just throw it out there, but that's just...
I think any of the Auctioneers Association group would support anything that you might bring to them. If we need to do it that way instead of bringing it for this task force, that we can certainly do that for you.
The bill that might come as a result of the task force already includes statutes in 2 chapters. I don't see why it couldn't include statutes in 3. But I suppose who would oppose it? That's the real question is, if you were to try to redefine that, what would you find that needed to be worked out or compromised on? But the legislature itself, sale and execution in particular, seems like low-hanging fruit that should be updated.
But because we don't have those statutes here, whereas the motor vehicle statutes were clearly reviewed against the codes, I think that slippery slope for us.
There's certainly a lot of interest among court clerks and sheriffs as far as the procedures they have to do, and I'm sure they would want to comment and be engaged in this. I wasn't meaning to circumvent that, but I thought we had some things that seemed to be just, here's what we're looking at, modernizing the licensing laws, and here's some other additional suggestions that you might consider beyond that. So we can, as the process moves forward, make sure those folks know and they can have opportunity to ask.
Ready for your official presentation?
Such that it is, yes. So to answer the question about the status of the recovery count, it closed out the previous fiscal year at $290,024.
And our minimum requirement is $250?
$250. And so far this year, let me tell you how much has been added to it.
About 20.
A total of $14,750 that's been added. That's where it currently stands right now.
So the question was, so the association brought forth a suggestion to change from a recovery fund to a surety bond. And in my initial submission, I supported that. I'm not sure, exactly where we stand on that. I could get behind that. The question was whether or not that would create a financial problem for the state, and I don't know that you're in a position to be able to answer that. that's the bullet point that we're looking at, is whether or not this task force is going to make a recommendation to maintain the recovery fund or to switch the recovery fund to a surety bond. So there are, different arguments for the validity of doing a surety bond versus the recovery fund. Commissioner Morris pointed out how difficult it is for a damaged party to collect from the recovery fund, and yet that those funds do other things, which provide CE seminars to licensees, and so there's that aspect of it. The surety bond may make it easier for a damaged person, would likely make it easier for a damaged person to get some kind of remuneration if they were financially damaged. But it would ultimately end up costing the licensees more, which was Commissioner Morris's point. And so we wanted you here for that conversation, pros and cons.
Okay, so essentially, if I'm trying to distill it, how much it costs the licensees right now under the current model, excuse me, what they're funding into the recovery account versus if we switched over to a surety bond,
Right.
what that would cost the licensee. Okay. So I clearly did not do my homework. I have asked the director of this program to track down some of that information. So if we could circle back to this in a little bit,
Okay.
with carry on with some of the other business, and I'll just tug on your sleeve, let you know when I've tracked that down.
Okay.
So yeah, and I think would it be creating a problem? I mean, that's kind of our bigger question, is from your perspective or from the state's perspective, would it create a bigger problem to make that shift than it would solve for the consumer? And that's, I think, kind of where my dilemma is on that as well.
So broadly, the Auctioneer Commission is doing a good job of maintaining its statutorily required self-sufficiency. So I wouldn't have just an initial concern that the Auctioneer Commission would end up getting sunsetted if this change was made. Of the $225 for renewals, Roxana just responded to me that 50 of it is what's slotted to the recovery account. So if you were to structure that differently, just off the cuff, I would think that you could probably come close to a similar impact on the licensee as to a surety cost. I would have to look at some of our other programs that have sureties versus ones that have
From my experience, it's $100, for a surety bond per year. Now we're paying $50, so you're talking about another $50 for the licensees per year.
Okay.
Well,
for the
it's
same.
50 every 2 years because we have a 2-year license renewal.
Whatever.
So
But yeah.
So it would be $150 a license period more for a licensee.
Okay, so in your personal capacity, the surety bond that you carry
$100
costs
a
you
year.
$100 per year,
Right.
rather than, to your point, the
$25 per
So
year.
it's
Yeah, so it's
25,
another $75 a year.
right. I mean, so I really think that would be for the licensees to talk about the benefit to the consumers versus the additional cost that you would face within the industry.
I recommend we table this discussion. We've got enough to put in front of the legislature with what we've got already, and I don't think we need to get into this conversation.
Second. Any other discussion? All in favor of tabling, say aye.
Aye.
I guess we're down to general discussion now. Carter, we got yours. I mean, not Carter. You got all what you wanted to get out. Okay. Anybody else got any? Kenny?
I would like us to consider adding in the definition of auction, where it's oral or written exchanges, adding the word electronic.
In the definition section?
If we're going to modernize the auction law, I think the word most of what we're talking about is the electronic part of it.
Is that a motion?
Second.
Any other discussion on that? All in favor, say aye.
Aye.
All opposed? All right. Anybody else got anything?
This part, you did have public comments, or was there any other
Well,
public
I
comments?
can assume that
They got them in?
they got it all out of their system.
Yeah.
Is that conduct?
Here we
No,
go.
not completely.
Got one taker.
Addison Russell, on behalf of the Tennessee Auctioneer Association, I lobby for them. And I just wanted to speak to Mr. Connor's point about the judicial sales. And I don't think that it's necessarily outside of the scope of the statute of the task force. The task force was to modernize and update auction laws of this state. It didn't say we had to stay in Title 62. And as Mr. Connor pointed out, we've been to Title 55 already. And I know that you're probably not prepared to do that today, but I would like to offer up that on behalf of the association, I can work with Mr. Connor and the county officials to sort of come up with some suggestions, and that we can send maybe language out for comment from the task force or any other party that would like to join in on that effort. But I do think that it could be good for not only the industry, not only the counties, but also the consumers of this state, and sort of promote the auction method of market and be of convenience to the counties and consumers. So I just wanted to put that on record, and if maybe you want to make a motion that we could look at that to incorporate into our other recommendations moving forward, or however you wanted to handle that. But I wanted to offer up those services.
Question for you. Is that something that could be completed and have in a draft form that we could do electronically as a task force to speak to before the end of the year, or would we need to call another meeting?
No, I don't think it's necessary to call another meeting. I don't know that you can maybe vote electronically due to this Open Meetings Act. What I have done with other things is, and I think legal counsel is here, maybe can speak on that, but to send something out and ask for comment back. I don't know if you can take an official vote electronically, but maybe you can if there is a necessity for it. Open Meetings Act is outside of my purview.
Denard, did you want to comment on that? I think we all want to avoid another meeting if we can, so
right.
Let's rely on Denard's crack legal judgment here.
Yeah, that's true. Hello, everyone. My name is Denard Mickens. I'm one of the chief counsels here for regulatory boards. Just to speak to briefly the Open Meetings Act, you can do a meeting electronically. It would have to be, though, in so there's certain provisions that you would have to provide for. We'd have to do a statement of necessity to the Secretary of State. We could do it over the phone line, but we'd have to have it in a place where the public could come and make comment. But we have done those kinds of things before. We could set it up, so maybe we could open this space and everyone could participate by telephone from someplace else. Or whoever could be here in person, but we could do that. There's ways to do that if you would rather do that, but it would, as Addison spoke to, we would need to create a statement of necessity for the Secretary of State and follow all the provisions of the Open Meetings Act. We could do it without being everybody here in person.
So basically, we can do a conference call. We cannot vote by email.
The part of the Sunshine Act, the Open Meetings Act, the public would have to be able to observe and pay attention to wherever two or more of you all meet. That is considered a meeting, and so that has to be open to the public.
We could actually have a conference call here, and if there was any locals that wanted or could come, they could come and have the conference call from here. Am I understand that correctly?
Yeah, that's right.
We could have the conference call here, and if there were some that could come or attend from Middle Tennessee or Nashville or something, we could have it here and have the conference call here.
Sir?
Okay.
Although to Addison's point, I guess, about the necessity of meeting again, because I think what you were talking about was that maybe we could have comments that we would give to the legislature about the additional pieces, because I think that there are so many items that we've touched on that a lot of us would have individual comments to the General Assembly. So that potentially could be wrapped up in the kind of the broader discussions that we have with the General Assembly. Is that what you were alluding to, Addison?
Yes, I think, and maybe not so much that you even have to have a conference call on this item. If you just make a motion that being David, the County Officials Association, sort of in conjunction with someone looking at this. And then once you'll submit your recommendations to the legislature. Once legislative legal spits back out a draft, that can be sent out for your review at that time. And I don't know that it necessarily takes a vote from the committee, if that's something you would be comfortable with, entrusting that to Mr. Connor to work with others interested in it. Was sort of where I was going.
Chairman, let me make an additional attempt at a motion. I would move that we include a recommendation that if the legislature moves forward with drafting a bill to address this, they make it broad enough that it can include revisions to other statutes related to auctions that need to be modernized.
Second.
Discussion on that?
Why we can't just say exactly what you said. Just let's take a look at places where sales are limited to outcry bid calling and broaden that a bit.
So let's see, you would, that's a motion to amend, or all right.
Or maybe I really move to delete the motor vehicle statute from that.
I was just trying to get something even less burdensome, but basically just to say that there are statutes with regard to courts and sheriff's offices that have to conduct sales, and they're antiquated. If we could just limit it to those.
Sheriffs and
Limited to government type sales. They have some laws about what can be done.
That's fine.
That's fine.
Okay. And I think some of them have certain times that the sales have to be constructed, and that he's wanting us to try to look at that.
It's not a government sale; it's a judicial sale.
Okay, that's a better word. Yes,
because it's not a government entity selling its own stuff. It is the result of a court proceeding that would order the sale of things. The way it says now, it has to be done between 10 and 4 from outcry from the location. That could be updated.
better word.
Okay.
Thanks, Will.
Well, we've got a motion out there, so I won't make this motion until we do it. But I think the key phrase is judicial sale and execution, correct?
Sale and execution is a judicial sale.
Right. And so that's what our motion, I think, is what we're trying to look at.
Right.
I think a foreclosure is too.
Yeah.
There can be a number of different ways a court clerk may be ordered to partition property as a part of probate. I mean, a lot of things.
Well, that's why I said
I've not reviewed
that's why I
all
was
of
just
those.
saying judicial, because when you use the word court, it's now made it judicial. So.
Other discussion?
Could we repeat the motion before we vote?
I'm going to withdraw the old one and try one more time. Make a motion that we request that in preparing legislation, consideration be made for modernizing statutes with regard to judicial sales.
Second.
All in favor say aye.
Aye.
All opposed? Other business?
I'd like to make a request. When you get the final version of whatever it is,
It's going to be circulated, is my understanding, right?
Yeah, I think we could do the same as what we've previously done, where we would post it online to our website, and then also, Dustin, have we also emailed it to the members? Okay.
and then when we have an opportunity to discuss it further,
Or another meeting, I think, to, I assume.
We could.
Mm-hmm. Yeah, I mean, you're right. Anything could be misinterpreted or not correctly done is the way everybody understood it, so. Right. If we need to call another meeting, we will.
Mr. Chairman, what's the legislative expiration date? What was it? Okay. Do we know that, or we don't know that?
Is the date that
when
the
do we have
task
to have
force
something-
ceases?
And
Is
when
it
do we
the
have
end
to
of
have
the year?
something?
At the end of the year, yes.
Yeah,
12/31.
Yeah, 12/31.
So,
So we have
That's just
time between now
recommendations,
and
which
then
you've
to have a
already-
telephone meeting if you want to call one to discuss whatever we're going to discuss.
so just everybody look at their calendars.
Could we just make a motion that if anyone, after they review the draft, would like to call a meeting, that they notify the chairman to call a meeting, so that any one person
I
could?
think we can just
do that,
assume that
or
that's
just,
right.
Okay. Go.
Any other business?
Move we adjourn.
Motion to adjourn. Second?
Second.
Thank you, everybody, very much.